That just doesn't change the court date. It does change. Mr. Blatt, can you come on the Zoom call?
Yeah, can you hear me?
I can.
Okay.
So this is on for pre-trial. So you don't have an attorney, is that correct?
All right. Quick heads up before we go any further. If you're new to sovereign citizen arguments, you're about to hear a lot of confident-sounding nonsense that has been rejected by courts for decades. Watch how the judge repeatedly tries to steer this back to reality, and watch how hard the defendant resists that.
I'm not sure I need one yet.
Okay.
Can I have your name? It says DC.
Your Honor, if I may, a couple of things.
Yeah.
First of all, the state has received a supplemental report and is prepared to establish probable cause at this time. And then also, if the defendant is electing to go pro se, the state would request a pro se colloquy.
Okay, I think that may have already happened. But in any case, so Mr. Blatt, right now, this is on for a pretrial, which is the opportunity for you and the state to discuss the case or maybe come to some sort of resolution. And then it can be, and right now it's set for trial. Otherwise, it would continue on to trial. Your trial confirmation is October 22nd. And then the trial itself would be October 29th and 30th. So I guess where do you said you don't think you need one, but which tells me that you don't have one at the moment. So I guess how do you see this case progressing and playing out?
Can I have your full name and the prosecutor's full name?
My name is Sam Meyer, and the prosecutor's name is Ms. Kidmacher.
Is it Meyer?
Yes.
And the prosecutor's name again is
last name is Kidmacher.
Okay, and first name?
It's Gabby.
Okay, and can I see your oaths of office and official bonding information?
Well, again, speaking only for myself, the answer to that is no. I don't have it on me. I don't carry around with me. I haven't. It's not necessary for me to post my bond. And the person who needs to, I'd like to know some information from you as to where you see this case headed.
When the officer stopped me, if I were to tell him that I have a license, I have insurance, I just don't have it with me, I don't think that would cut it with him. It's important for a driver to have his license and insurance in order because operating a motor vehicle is a potentially hazardous occupation. The same is true with being a judge or a prosecutor. It's a potentially hazardous occupation because people could get hurt. They could go to jail unlawfully if something goes wrong. So a judge needs an oath of office, which is anomalous to a driver's license. And
right.
The bond is equal to the insurance that a driver would need.
This is a classic sovereign citizen move, demanding a judge's oath and bond as if that somehow invalidates the court. Here's the reality. Judges don't have to carry paperwork, like a driver carries a license. These records exist, they're filed, and they're publicly accessible. Refusing to accept that doesn't create a legal loophole.
To have.
So I do have a oath of office. It's good. The auditor's office. If you want to go there and get it, you can certainly look at it. But like I say, I don't carry it with me. I don't have it on the. I don't have it posted on the wall. I don't believe I'm required to. You are required to have a driver's license when you drive a car. But I don't. We're going down a rabbit hole, which really isn't that productive for you, Mr. Blatt. I'm trying to figure out, where you see this case headed. And it's either going to be set for trial or there's going to be some sort of resolution. And if you think you've identified some issues with me or you haven't seen my oath of office, if that's an issue on appeal you want to raise, if you get convicted, you can certainly do that. But we're not going to spend a lot of time on, things that don't really matter with regard to your case. You might not believe that it doesn't matter, but it really doesn't. Right now, you're the one charged with driving with license suspended in the 3rd degree. Your options are go forward to trial, which I've told you when that's scheduled on October 22nd for trial confirmation on October 29th and 30th. And that's kind of, so I guess I'd like some answers from you as to where you see this case headed.
Okay, you just said you don't want to spend a lot of time, but if the prosecutor wants to spend 3 months of my time in a jail, then you have to afford me the time I need to get due process. Now,
Yeah.
at the beginning of this Zoom hearing, I heard you say that the state is charging me, but the paperwork I've been giving says the city of Tumwater is charging me. Could we clarify that?
Yeah, I can clarify that. And that was the mistake on my part. You are correct. It is the city of Tumwater.
But the city of Tumwater is franchised by the state of Washington, right? And it's using Washington statutes to prosecute this.
Notice what's happening here. He's trying to confuse state, city, and court jurisdiction to imply the case is illegitimate. But municipal courts routinely enforce state statutes. This is normal, boring, and very settled law. Question for you. Do you think confusion is intentional here or genuine misunderstanding?
Case, right?
I don't know about the franchise aspect of it, but it is a municipal case from the city of Tumwater. A lot of times municipalities incorporate on criminal codes and misdemeanors, they'll incorporate the revised code of Washington into their municipality with the law within that municipality. So yes, it could very well be prosecuted under a statute from the revised code of Washington.
Well, that raises some concerns with me because I see to your left, you have the plaintiff's flag behind you. And so are you a neutral entity or are you part of the prosecution?
Yes, I'm a neutral entity. I like to think that, yes.
Then why do you have the prosecution's flag behind you?
It's not the prosecution's flag. It's the flag for there's a flag from the United States of America. There's a flag from the Washington state, and then there's a flag for the county. I am a Thurston County District Court judge. I elected and have jurisdiction within this county.
But the state of Washington enfranchises the city of Tumwater to prosecute people under its statutes, the state statutes. So
I don't agree with your terminology there in terms of what they franchise. So Tumwater is a municipality. They have some discretion as to how they can choose to enforce laws within their municipality. One of the ways they can do that, and they're not alone in this, a lot of cities do this. Not everybody. Lacey, for example, has their own municipal code, but Tumwater might not. They might adopt the RCW for things like driving with license suspended in the 3rd degree, DUI, and misdemeanor and gross misdemeanor things and things of that sort. Of course, felonies obviously would be under the revised code of Washington, and that would go to Superior Court. But this is limited jurisdiction, and we only deal with misdemeanors and gross misdemeanors. We're contracted to provide court services for certain municipalities within Thurston County, including Tumwater, Lacey, and to name a couple, and that's why you're here. That's how you're here.
are you going to be the judge throughout all the hearings in this process?
I don't know. No, we have a rotating schedule and may or may not. I'm just the lucky one today.
Oh, this is going to put a burden on me to check all the judges' oaths of office and so on.
No, it's not. And don't worry about that. Like I say, our oaths of office are on file, and you can go look at any of them anytime you want.
Okay, I've been given this paper by the court. It says criminal traffic.
Yes.
I'm very upset
Yes.
about being called a criminal. I'm not a criminal, and I want to clear my name, believe me.
Well, you haven't been convicted of this charge yet, but driving with license suspended in the 3rd degree is a criminal charge. It's a simple misdemeanor. It carries with it a maximum penalty of 90 days in jail and $1,000 fine. As a practical matter, that would be highly unusual for anybody to receive that sort of jail time for a charge of this sort. But driving with license suspended is a criminal offense. It just is, and that was done by the legislature. And
Now, driving and traffic are commercial terms. I mean, you could check it in Black's Law Dictionary. And the police narrative says that I had a passenger in the car. Passenger is also a commercial term. And passenger, according to Black's Law Dictionary and extensive case law, says that it's a customer who pays you to transport him, which is basically trafficking. There's nothing in the police narrative that says that to support.
This is where the fantasy really falls apart. Black's Law Dictionary is a dictionary, not a magic spell book. Courts rely on statutes and case law, not cherry-picked definitions. And when a judge says, "I've heard this before, and it never works," that's not opinion. That's experience talking.
The presumption that I was engaged in any commerce or traffic. So the case should be dismissed on that basis.
No, that doesn't matter. If you get behind the wheel and drive a car, you need a license. And there are certain rules and there are certain things happen that can cause that license to get suspended. If it gets suspended and you get caught behind the wheel driving and the state can prove it, then you would be found guilty. Those terms of, Black Law Dictionary, whether they call that a passenger or not, I'm not really sure, but the law that applies in this case, like I've told you before, is the Revised Code of Washington, which deals with licensing and when people can drive and when they're eligible to drive. So all those things you say about, and again, you might not believe me, but those things you talk about, whether it's a passenger, whether it's a commercial term, none of that matters. The only thing that matters is, were you driving and were you validly licensed, or was your license suspended? And that's it. That's what this case is about.
Sir, I was traveling, not driving. Driving is a commercial term.
Okay.
At the time, now I know that anything I say can be used against me in court. I'm fully aware of that.
So hang on just a second. Well, it can, but you shouldn't admit that. If by traveling, you were in an automobile and conducting that by having an engine running and applying pressure to the gas and brake and turning the wheel, whether it's traveling or driving, that's kind of like, 6 of one, half dozen of the other.
Sir, I need to make something very clear at the very outset. I'm not going to deny that I was traveling in my private property automobile on the date in question. I'm not going to argue. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about at trial. My defense is going to be something completely different. Now, I noticed something on the website for the court. It says jury instructions or jury guide.
Okay, so hang on just a minute. Before we get there, can I take that to mean then that you wish to go to trial on this?
I wish to be left alone.
Okay, well, that's what everybody wants. But right now, where you are is you're charged with the crime of driving with license suspended in the 3rd degree. So again, I've went back to this before. Your options are either come to some sort of resolution with the city, or you're entitled to a jury trial. And then if you win, and you started mentioning, I want to stop you when you started saying things about jury instructions, and that means if you wish to go to trial, you can do that. And but we're going to have a different conversation about your ability to represent yourself, which you certainly have a right to do, but I need to create a record that you're doing that, knowingly and voluntarily with open eyes. The possibility is still in place to have an attorney appointed to represent you, but when we started this conversation, I'm not sure that I need one. Most people, when they're charged with any sort of criminal offense, and again, this is a criminal offense, they take advantage of when they're offered an attorney at little or no cost. But again, that's entirely up to you. But what I need from you is a decision point on how you want to handle this case. Either come to a resolution or go to trial. And if you go to trial, then we're gonna, which is fine. Trial dates are set, but we're gonna have a conversation about a few things before we get to a jury instructions. So again, I need some input from you as to what you wish to do.
I only participate in fair trials, and I have concerns about whether I can get a fair trial in this court. Can I?
Okay. Well, the trial, if it's a jury trial, the people who are going to determine your guilt or innocence will be 6 jurors who will be impaneled from the jury rolls within the county, and it'll be up to them.
There'll be 6 jurors and an alternate juror, right? So that's 7, right?
Typically, yes.
Well, this jury guide that you have on the website says that it's the juror's job to listen to all the evidence at trial, and the judge is to deal with legal issues, not the jury.
That's true.
That concerns me about whether I can get a fair trial, because the whole purpose of a trial by jury is to consider issues of law. Otherwise, why do we need a jury? Because
Right.
I've already stated I did the act. I traveled in my automobile on the date in question. I'm not going to deny that. That's the first thing I would tell the jury if it goes to trial.
Okay,
And I'm
so
going
then,
to bring up to the jury the issues of law. My question to the court is, how would
so
the
here in a
court
second, I'm
have
going to stop you for a second, because you're very wrong about something, okay? You are very wrong about something. The jury
This might be the most jaw-dropping moment so far. He's openly admitting the conduct and planning to tell the jury he did it. That's not bold. That's catastrophic. Jurors don't nullify laws on demand, and judges don't let defendants redefine reality mid-trial.
jury does not decide issues of law. The judge does. The jury decides issues of fact. The jury decides what did happen or not happen. That's what the jury decides. The jury's the fact finder. The judge decides what law the jury listens to. And that's just the way it is. And so when you say the jury decides the law, that's not correct. That's, there's no court in the country that where the jury, in this country anyway, where the jury decides what the law is. The judge decides what the law is. And you can look at any court in any state, in any jurisdiction in the union, and that's the way it is. And so the judge, and then the judge will, following the trial, following the evidence portion of the trial, the judge will instruct the jury on what the law is, and then the jury determines whether or not that person, you, did or did not do what you're being charged with. That's a fact inquiry. And what you're being charged with is driving with license suspended in the 3rd degree, and the jury's going to decide, did this happen or did it not? And if you have issues with the law, they're not fair, you might think this is unconstitutional. I've heard many times people think that, it's not constitutional for a state to require people to get licenses. It is. I've heard that, that there's some, the right to travel is being impinged by the requirements of a license. It's not. All of those things have been looked at by courts much above me, have decided that that's what the law is. And any instruction you're going to get on the law, or the jury's going to get from the law, has all been vetted in front of, courts of appeals and the Washington State Supreme Court, and that's the way it is. But you need to be clear. The jury does not and will not decide the law. The judge will determine that. And what I was going to say to you in advance of that is, you might not get to present. Maybe this is why you think you don't get a fair trial. Some of these legal issues you wish to argue, you might not be able to do that. Probably not, because that's just what the law is. And I know what the law is based on my experience. And I may or may not be the trial judge if it goes that far, but I just know that to be the case. So we're going to stop here for a second because but don't leave, because it's at 2:30. And we have some other people coming on at 2:30. We're going to take care of those cases, and then I'll come back and speak with you some more. All right?
I understand you believe all that nonsense, but I'm going to have a trial by jury, not a jury trial. A jury trial is 6 people that only consider the facts, and basically juries have been neutered since the rules of evidence have been implemented in the 1936. But this jury is going to hear the law as well as the facts, and I'm just curious. I would like to know how the judge would, how the court would stop me from communicating with the jury.
Okay, so Mr. Blatt, I'll come back to you. So I think when last we talked, you said you wanted, a trial by jury or a jury trial. To me, again, that's...
No, I did not say that. I want to be left alone. That's what I said.
Okay. Well, again, that's what everybody wants. So do I. But nonetheless, where you're at right now, you're charged with driving with license suspended in the 3rd degree. And you had made the distinction, I think you had, and correct me if I'm wrong, I don't mean to misstate things. You were making a distinction between jury trial and trial by jury. And I'm not sure exactly what you meant by that.
Well, a trial by jury, which is what we used to have before the passage of the 19th Amendment, when women got the right to vote and therefore got the right to sit on juries. Juries had the right to investigate the crime scene, to consider the law, to nullify. basically it was a trial by jury. Now that it's a jury trial where the jury's neutered, there's only 6 of them, they're cut in half, and they're not allowed to, they're scurried out of the courtroom every time there's important adult issues to consider, like children, and that's just nothing. That's not a trial by jury. But anyway, I have a dispositive motion right now that might settle everything here.
Okay, we'll set that for a motion hearing, though. We do those on Monday morning. Did you file it in writing?
I'd like to do that. I prefer everything to be in writing. So can we schedule a motions hearing?
We certainly can. But before we do that, I want to talk to you about, it again appears to me, well, we're going to do a couple of things. First of all, I am going to find, based on, there's a police report filed in sector. Based on that, I'm going to find that probable cause exists. And then we're going to set conditions of release, which basically are make all your court dates, don't drive without license or insurance, and don't have any other criminal law violations. Based on our conversation thus far, it appears to me that you wish to represent yourself at trial. Is that true?
I don't understand that terminology. I am myself, so why would I want to represent myself? Only corporations need to be represented because they can't speak for themselves in court. I'm not a corporation. I'm a human being.
So you wish to proceed to trial without a lawyer?
No, I wish to be left alone. That's my only wish.
But yeah, that's true. But that's one that's not going to happen in terms of this case. It is set for trial. The trial will take place. And my question to you is, you have the right to have a lawyer with you during trial. And you also have the right to go it alone, all by yourself. And so, Mike, those are your 2 options. Which of those do you wish to take?
Well, I have some concerns about being represented by an attorney because attorneys in this state are licensed and franchised to make a living in the plaintiff's courtroom only at the pleasure of the plaintiff, right?
No.
Well,
I mean, you're under you have a lot of unfortunate and incorrect impressions. You really do. And that's really unfortunate. And I'm trying to, let you know. And again, you're just wrong about a lot of things. And I'm sorry about that.
Does the plaintiff have the power to disbar the attorney if the
No, absolutely not. I don't know why you would think that. That's completely not true.
Well, I personally know attorneys who have been blacklisted because the courts don't like the way they defend clients because they do it too effectively. For example, Lee Eckhart was not disbarred because he never did anything wrong, but he was blacklisted, which means any client he hired automatically lost. And he had to inform each client that wanted to hire him. He would lose.
I don't know anything about that individual. I don't know anything about that. You're asking me, I guess, in this court, whether, or just generally, whether the plaintiff, in this case would be the prosecutor, has the right to disbar attorneys. And the answer to that is no, they don't.
The plaintiff is the state of Washington because Washington.
Well, in the city of Tumwater, in this case, remember we talked about that.
Yeah, but the city of Tumwater is a subdivision of the state of Washington.
But they can still bring case. So again, what do you want to do for your upcoming trial in terms of an attorney, or have one with you, or go it alone?
I'm not sure I need an attorney at this point because we'll have to see.
So again, that's a binary choice. So then from that, I can tell you you're choosing to go it alone. And have you ever done this before? Have you ever conducted a trial of any sort?
And here's the hard truth. Contempt isn't theoretical. Judges can and do remove self-represented defendants who refuse to follow rulings. At this point, the courtroom isn't debating law. It's managing damage. Let me know in the comments. Should courts be more patient with this? Or is this already too far?
Just look at my record.
That's, again, I can see your record, but that none of it tells me whether or not you've done a trial by yourself before. So, Mr. Blatt, have you ever conducted a trial before by yourself?
I didn't come here to answer questions. I'm sorry.
Okay. Okay. So then I'm gonna talk and then we're gonna set we're gonna set a date and then we'll
I need to
conclude the
bring
hearing.
I need to bring something to your attention, if I may.
I'm sorry?
I need to bring something to your attention. The United States Constitution at Article 1, Section 1 states that when the state is a party, which is this case, excuse me. Let me get my glasses. When the state, it says in all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. This is in the United States Constitution. Now, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary. This is a fundamental principle. When the state is accusing a citizen of a crime against the state can't take the defendant to trial in its own court. That would be a conflict of interest. It has to take it to a neutral court, which is the United States Supreme Court. It says it clearly here at Article 1, Section 1 in the United States Constitution.